Thank you, Erica. And thank you, I want to start by saying thank you to everyone for coming. It's really exciting and energizing for me to see that you are willing to spend your lunch hour thinking through the interesting issues that are raised by Canada 150. And in particular, I'm really energized and excited that you're willing to think about the future of the Supreme Court with me here today. And I'll be eager to hear your own ideas and questions in the Q&A after my presentation. Let me also say a special thank you to the law students who are here. I know it's a very busy time of year, and so I appreciate your willingness to step out of the end of term whirlwind for a few moments in order to come today, so thank you. Let me also extend a very warm welcome to the students from Ms. Pasquarelli's law class at North Middlesex District High School and Mr. Needham's law class at North Landam Secondary School who have joined us today. I hope you are enjoying your time at the law school, and we're really delighted to have you. One final thank you, and that is to Karen Kuhneman, Susanna Ayers, Amelia Greco, Danielle Lacasse, and Corey Meingarten, who have organized this event, and I really appreciate their expertise in all that they do. If anything should go awry, it's all on me. You can blame me. So I think a law school is a really interesting venue to have one of these Canada 150 lectures, because the foundation of a law school, what we're trying to achieve here, is to interrogate and contemplate what it means to organize a society and what it means to live together and live together well. That's what we're trying to do in a law school. And my talk today focuses on two legal institutions that happen to also be two prominent features of Canada's modern public life: the Supreme Court and the Constitution of Canada. But of course, and Professor Chamberlain mentioned this as well, of course neither one is 150 years old. The foundations of the Constitution of Canada have a much more expansive history than an anniversary of 150 years will mark. And the Supreme Court was established in 1875, and that's because there is no text of the Constitution that guarantees or requires the existence of the Supreme Court. Instead, it requires political consensus and political will, which couldn't be gathered together until 1875. And so the special anniversary that we are marking is the anniversary of Confederation, right? The coming together of individual provinces that were trying to reconcile these ideas of diversity and unity. And we're also marking the document that crystallizes Confederation, the Constitution Act 1867. And given the very important moment of statecraft that is represented in Confederation and the Constitution Act 1867, this anniversary is certainly, I think, a moment that should inspire us to reflect on the past and on the present, and also to rethink and reimagine what we're doing in the pursuit of justice going forward. And so as part of my small contribution to this endeavor, I'd like to talk today about the future of the Supreme Court and its relationship to the Constitution. So, what part of the Supreme Court's future am I talking about? So a couple of weeks ago, I was at a conference that was hosted by the Supreme Court, and it was also reflecting on what's the Supreme Court all about, what's in its future, what are its most pressing issues. And as part of this conference, the court organized an essay contest for law students, and law students were asked to contemplate and imagine the Supreme Court of 2067, right? So the Supreme Court in 50 years. And the two winners who were announced at this conference argued that the Supreme Court of 2067 would have at least one judge who was a robot with artificial intelligence, right? So a human-made machine with human intellectual capacities sitting on the Supreme Court and making those decisions. Now, this idea of a robot and artificial intelligence at the Supreme Court is a really interesting issue. Raises ideas about what humanity brings to adjudication and what artificial intelligence might mean for access to justice. And these are really glamorous issues thinking about the future of the Supreme Court. They are not, however, at all the issues that I'm going to talk about today. I want to talk about the future of the way that we think about the Supreme Court. And I'll be arguing that I think we should be thinking about the court differently than we currently do. And then I'd like to point to some of the practical, positive implications of shifting our gaze and rethinking the way that we think about the court. So to make my argument, I'd like to speak to three primary issues. First, I'm going to start with what have we been thinking about the court? What's the dominant narrative about the court that we see in law and in politics and even in the media? As with all things, we tell ourselves stories about the Supreme Court in order to make sense of its role and its significance in the world around us, right? And these stories are told through particular lenses that help us see the court in a way that makes sense for us, right? We use these stories to understand the court and to see it clearly. But it seems to me that there's something missing in the current dominant narratives about the Supreme Court that are told. And so I'll be arguing that the lenses through which we're looking at the Supreme Court right now are actually clouding our vision rather than sharpening it. And so these lenses are acting as blinders and helping us to ignore some of the messier features of the life story of the Supreme Court. Now, thinking through this dominant narrative and what is missing, the next question, of course, is, does it matter? Right? In some sense, all stories that we tell ourselves about the world tidy up some of the messy dimensions of life. But I'll be arguing that the dominant narrative about the Supreme Court is based on an incomplete understanding of the Constitution of Canada. That is, when we hold up the stories about the Supreme Court, when we hold them up to the light of Canadian constitutionalism, we see that they are somewhat impoverished, right? We see that there are some gaps. We see that they are thin and flat, where they should be thick and textured. And so in the final part of my talk, I'd like to point to some of the thickness and texture that is revealed when we adjust the lenses through which we look at the Supreme Court. And then I'll speak to some of the positive effects that I think this redirection of our gaze can generate. Okay, so let me start then with the dominant narrative. What is the dominant narrative that the law tends to tell about the Supreme Court? What is the story that we've been telling about the court? And I'll be focusing on three principal features of this story. So the first part of the story speaks of the court as Canada's most powerful legal decision maker. And this part of the story relies on the idea that courts are our legal decision makers and that they are arranged in a pyramid with the Supreme Court at the top. And on this view, we have this stable vertical hierarchy of legal decision makers. And it's these decision makers who answer legal questions and interpret the Constitution. And the Supreme Court sits at the top of this. And in its position at the top of the pyramid, the court has been called the institution at the center of public life in Canada and home of the most important decision makers in the country. The second part of the dominant narrative is to say that the court is the guardian of the Constitution. So the story that we tell about the court says that when it comes to the Constitution, the courts, and ultimately the Supreme Court, are the interpreters of record. The Supreme Court is ultimately the keeper of the Constitution and the keeper of constitutional meaning. And so when we need an answer to a question of law or the meaning of the Constitution, we should turn to the Supreme Court rather than to other branches of government. Indeed, the Supreme Court is considered the guardian of the Constitution and is responsible for guarding the Constitution against incursions from the executive and the legislature. And we see these beliefs at stake or come to the forefront whenever a reference is called. Right? When society is struggling with issues of Senate reform or how to recognize the right for same-sex couples to marry or how to deal with calls in Quebec to separate from the rest of the country, the instinctive response has been to call for a reference at the Supreme Court. Now, this part of the story also tends to reflect the idea that the Constitution that the Supreme Court is guarding is bijural. And that means that it's made up of two legal traditions, the common law and the civil law. The third part of the dominant narrative that I want to point out is the role of the court in resolving disputes, and that this is ultimately the core function of the Supreme Court. Right? The dominant narrative tells of a Supreme Court whose primary role is to resolve legal disputes, and that when the Supreme Court issues a judgment, that judgment is final and decisive, and it's the definitive word on the law. So on constitutional issues, at least, only the court then has the power to change these interpretations. And so the court is seen as the final legal word. Now, putting all these features together, the dominant narrative tells of a Supreme Court that is essential to Canada's constitutional order. It has been said that we can't imagine Canada's public order without the Supreme Court, that it is a foundational premise of Canada. Okay, so that's the dominant narrative. The next question then is, what's missing? And I think that what's missing from this dominant narrative is that it is based on an incomplete account or an incomplete understanding of the Constitution of Canada. And I think there are three features of the Constitution in particular that the dominant narrative doesn't quite capture. And so I'm going to go through those three. So the first, remember we talked a few minutes ago about the Judicial Pyramid. And when we talked about that pyramid, right, it was the image of a vertical hierarchy with the Supreme Court at the top. And this is a very court-centric view, right? The courts and ultimately the Supreme Court are the primary sites for establishing constitutional meaning and resolving constitutional disputes. But this isn't actually an accurate understanding of legal decision-making or constitutional interpretation in Canada. When we look outward from the courts, we see that the court is always operating within a larger institutional framework that includes countless other actors and officials and decision makers. In reality, most legal decisions and most legal disputes are not resolved by the courts. They're certainly not made in the halls and the chambers of the Supreme Court. They're instead made in the greatest number by administrative decision makers within tribunals and boards and other agencies and government actors pursuing statutory mandates. And these legal decisions and disputes are also made in the negotiations between governments, between government officials, between individuals, as well as in the operation of government and in the everyday life of communities. Now, the Constitution gets meaning in each of these sites. Constitutional disputes arise and are resolved in each of these sites. And when we recognize this, we see that interpreting the Constitution and finding legal meaning is a shared project. It's not just a matter for the Supreme Court. And we also see that the judicial pyramid isn't a very satisfying or isn't the most satisfying image for representing legal decision-making. Instead, the more accurate image is flatter. Legal decisions and constitutional interpretation take place in a more diffuse or sprawling network of institutions, one that extends horizontally, right, and shifts, rather than one that is vertical and hierarchical and fixed. So that's the first part of the Constitution that I think is missing from the dominant narrative. The second constitutional feature that is missing from the dominant narrative is the idea that Canada's Constitution is actually multi-juridical rather than bi-juridical. So what do I mean by this? Well, you'll remember a few minutes ago, I suggested that the conventional narrative, the conventional understanding of the Constitution is that it's bijural. It's made up of two constitutional traditions, two legal traditions, the common law and the civil law. But this ignores the place of Indigenous legal traditions and governance in the conversation, the experience, the culture, and the claims of Canadian constitutionalism. So John Burroughs, one of the leading scholars of Indigenous law in Canada, explains in his work that when we look to the founding legal traditions in Canada, we see the operation of multiple legal traditions. In other words, constitutionalism in Canada is better captured by conceptions of multi-juralism rather than bijuralism. Burroughs explains that it's a mistake to write about Canada's constitutional foundations without accounting for Indigenous law. He says you can't create an accurate description of the law's foundations in Canada by only dealing with one side of legal history. So in this constitutionally plural environment, constitutional law has to explore. It has to explore the various orders of authority that are at work in Canada, each of which has its own mechanisms for legal decision-making, each of which has its own standards for legitimacy and authority, and each of which has its own language for understanding what is important in living a good life. And so the legal traditions of Indigenous peoples alongside the common law and civil law traditions thus belong in the constitutional conversation in Canada and should be found in the story of the Supreme Court as well. The third thing that's missing is that this idea that the Constitution is agonistic, and I'm going to explain exactly what I mean by this. So, think back to the dominant narrative. The dominant narrative suggests that constitutional disputes can be resolved and should be resolved. And remember, that's one of the core roles of the Supreme Court. That's what we expect the court to do, to resolve disputes and to give meaning to the Constitution. That's what we rely on it for. So what's missing here is the fact that Canada's Constitution is at least partly agonistic. So what does this mean? An agonistic constitution, and I'm drawing on the work of Jeremy Weber here, an agonistic constitution is one in which rivaling positions or competing ideas are at the foundation of the society that is governed by the Constitution. So the society or community is animated. It's given life by competing ideas about foundational governing values. And as a result, the foundational ideas of the community aren't neatly contained or packaged within one comprehensive, overarching theory. So Canada's Constitution is agonistic because for all of its unifying efforts and all of its unifying dimensions, it's also animated by these unreconciled claims, perhaps unreconcilable claims about the rule of law, about the division of powers, about the relationship between governments, and about the encounter of legal traditions. Now, in an agonistic constitution, in contrast to the dominant narrative, in an agonistic constitution, the impulse isn't to iron out all disputes and to smooth out all disagreements. Instead, the impulse is to take diversity and disagreement as we find them, to embrace them rather than resist them, and try to find constructive ways to have a peaceful community and a peaceful society regardless of these enduring debates. Again, in contrast to the dominant narrative, which fosters this instinct to smooth everything out, agonistic constitutionalism tells us or counsels us or advises us to sometimes just get comfortable with the discomfort of disagreement. Okay, so we now know the dominant narrative. And putting together these ideas, I'm saying that the dominant narrative about the Supreme Court is lacking or misunderstanding the Constitution of Canada. And in particular, what's missing is the idea that the judicial pyramid is flattening, the idea that Canada is multi-juridical, and the fact that the Constitution is partly agonistic. So the next question then is, does it matter? So what, right? Are we better off with the dominant narrative as it stands? Or do we have something to learn from a revised narrative? My answer, as you might have guessed, is that the the absences from the story matter, right? And that we definitely have something to learn from this revised account. We're not better off with just leaving the dominant narrative as it is. And so again, I'd like to point to 3 positive, practical implications of revising the story of the court to account for all of the things that we're missing. Okay? And I'll speak about expectations, I'll speak about appointments to the court, and I'll speak about judging as well. Okay? So first, rethinking the pyramid. When we rethink the pyramid, the judicial pyramid that we saw in the dominant narrative, and when we account for the flattening of decision-making, this changes our expectations of the court, and it changes our assessments of the court's significance. So let me explain what I mean by that. Now remember, as I've said, that the judicial pyramid isn't a satisfying image for how legal decisions are made. Our Constitution acquires meaning from a range and a more diffuse and horizontal set of decision makers. Now, when we accept this, right, our understanding of the Supreme Court as a supreme institution with the most powerful legal voice gets complicated, right? It's disrupted. That dominant narrative is disrupted. Rather, we come to see the Supreme Court as an institutional actor that's only one constitutional voice among many. Right? So within this architecture, within this horizontal configuration of institutions, we see that the responsibility for upholding the rule of law is a shared project. It doesn't rest primarily on the shoulders of the judges of the Supreme Court. Rather, the project of upholding the Constitution and the rule of law and finding meaning in the Constitution is a shared project that extends across all of our institutions, all of the country's public institutions and actors and decision makers. Now, on this revised view, there are certainly still times when the court's position at the top of the pyramid come to the forefront, right? Such as when the court decides that some legislation or some law is unconstitutional and thus strikes it down. But at other times, and indeed I would say most of the time, the supreme character of the court's decisions really dims and blurs as just one contribution to this very crowded map of constitutional voices. In this sense, the court's power and the court's significance can't be assumed, it can't be taken for granted at any particular moment. It will always depend. The significance of the court will always depend on the context, it will depend on the dispute that's being decided, and it will depend on the other decision makers that are involved. And so this shift in thinking of the court as a participant, or the shift in thinking to the fact that the court is a participant in a shared project rather than an ultimate interpreter of the Constitution, is to recognize that the court isn't a head engineer of some constitutional order, of our constitutional order. Rather, it is and these are the words of Shauna Van Praagh at McGill, a partner in an ongoing dance. A dance with many partners, with relationships that change, with constant changes in rhythm, direction, and coordination. And that this is a more helpful metaphor than the judicial pyramid. And so in every constitutional case, with every constitutional issue, the court is just this participant in a project of finding meaning and assessing disputes. It's not the umpire, it's not the guardian of the Constitution. Rather, it's dancing with other institutions and other individuals who also participate in their own ways in trying to find meaning and bring the Constitution to life. When we put the Supreme Court in this flatter institutional arrangement or architecture, we can never assume the weight or normativity of the court's judgments. The status and the significance of the court and its work aren't fixed as supreme. Rather, they're provisional, they're conditional, and they're shifting. So that's the first consequence, right? Rethinking the significance of the Supreme Court in the constitutional context. The second idea that I'd like to talk about, or the second way in which the dominant narrative is revised, deals with composition of the bench of the Supreme Court and who is chosen to sit on that bench, so the appointment process. So when we account for this fuller constitutional picture that I've tried to set out, we learn something about the composition of the bench and about appointments to the Supreme Court. And in particular, I'm focusing here on the multi-juridical quality, right, of Canada's Constitution. This idea that the Constitution is made up of multiple legal traditions. It seems to me that when we look at those multiple legal traditions, we learn something about how the court's bench should be composed and who should be appointed. Now, composing the bench of the Supreme Court is certainly a delicate matter, and it demands attention to multiple different considerations. This includes, though, constitutional considerations. And the constitutional factors include those that flow from Canada's legal traditions. The court is expected to manifest and pursue the highest ideals of the Constitution. And this includes manifesting the multi-juridical nature of Canada's Constitution, which we know, as we've already talked about, includes the common law, the civil law, and Indigenous legal traditions. Now, current constitutional law establishes that the composition of the court, right, who sits on the bench, is vital to the court's capacity to act legitimately and effectively. So to do its job, and to do its job in a way that is legitimate within the country. And the case law establishes that the composition is a constitutional matter. And as a constitutional matter, the court must have representation of both the civil law tradition and the common law tradition. And we see this in the constitutional guarantees of representation on the court's bench of jurists from Quebec. Now, by analogy, when we accept that Canada's Constitution is multi-juridical, here we find a constitutional argument that the composition of the court should also include, or must represent, not only the common law tradition and the civil law tradition, but also expertise in Indigenous legal traditions. So the claim of appointments of jurists with expertise in Indigenous legal traditions isn't one just of good policy. It's not one just about legitimacy or competency. It's rather one that has a constitutional character. It is backed by constitutional imperatives. And so this is we're at an interesting moment, considering that right now the Prime Minister is trying to decide who to appoint to the Supreme Court and who will be the next Chief Justice. And so these constitutional considerations, we'll see if these are reflected in the appointment, in the next appointment. The third and final part of this revised story that I'd like to talk about deals with the nature of judging. So I'd like to talk about patience as a judicial virtue. And this is a consequence of this agonistic character of the Constitution that I talked about. So recall a few minutes ago when I was talking about the agonistic character of the Constitution, right? And this means that Canada's Constitution is partly agonistic. It's animated by these competing ideals about foundational governing values. So if the Constitution is agonistic, it means that some of the disputes that come before the Supreme Court, they will also be agonistic. Okay? They will also deal with, or have at their heart, disputes that rest on these irreconcilable claims about how the country should be governed and what the governing values are in Canada. Now, with most cases, we expect the Supreme Court to resolve disputes, right? We've already talked about how that is one of the primary roles that we attribute to the court. And certainly that's true, right? Courts are a very important public mechanism for resolving disputes and ensuring that we can all live together peacefully. But when we take seriously the idea of agonistic constitutionalism and the agonistic character of some constitutional disputes, we can see that these types of disputes, these agonistic disputes, and their irreconcilable claims aren't really well suited to dispute resolution by a judge, right? Instead, these cases, I would argue, are those in which judges should actually exercise patience, where they should seize on patience as a judicial virtue. So what do I mean by that? So by patience, I'm talking about special cases, special agonistic cases, where the best course isn't to resolve the dispute, right? And the judges of the court shouldn't resolve the dispute that comes before them. Instead, what they should do is draw the parties' attention, draw the public's attention to the competing issues that are at stake and the competing claims, explain those issues, and then offer the parties a framework or a way forward that allows the parties to move ahead, but doesn't actually alleviate the tension that is between them, and certainly doesn't impose a solution upon them. In this situation, the parties to the claim are then left to negotiate and figure out ways of navigating their dispute and their diversity going forward. Now, this practice of patience by judges is somewhat strange, right? It calls on judges to resist the expectation that they resolve disputes. And this expectation certainly attaches very strongly, most strongly, to the Supreme Court. And so patience, this idea of patience as a judicial virtue, is asking the court to step away from resolving the tension between parties and instead hold the dispute in suspension or in abeyance. And just take the legal analysis to a point that imagines a path forward for the parties, but recognizes and respects the agency of the parties to navigate their differences. It's a role for the court to respect the capacity of communities and individuals, whether office holders or citizens, to deliberate and exercise constitutional judgment on their own, on issues of law and governance. And for those lawyers in the room, examples of these kinds of cases where patience has been exercised in some ways, and appropriately so, in my view, examples would be the secession reference, the Haida Nation case, and the second gun registry case dealing with cooperative federalism and the dismantling of the gun registry. So in conclusion, let me just say that perhaps you can see that at the heart, really at the heart of this talk and of these ideas is a weariness, right? A weariness about the stories that we have been telling about the Supreme Court and the claims about the Constitution that underlie those stories. It seems to me that the conventional accounts turn our attention away from really pressing issues of significance to our public order, to our everyday lives. Now, there may be comfort in having these less demanding stories, these stories that tidy things up, but I think there's also a risk of a loss of agency, of a loss of opportunity to participate in this exercise of adapting our institutions to meet the constitutional aims that we have and the Constitution to which we aspire. So I think one of the opportunities that is bestowed upon us by anniversaries like Canada 150 is to remind us of the contingency, really, of what we think are the best ways of knowing and doing things when it comes to law. And it's an opportunity to consider whether there are better ways of knowing or doing. It's an opportunity, I think, to seize our capacity to imagine and assess alternatives that are better suited to our aims and aspirations. And it's an opportunity or a reminder to reflect on how best to live together and how best to relate to one another. The retelling of the stories of the Supreme Court that I've tried to present today is just one small contribution in the service of those goals. So thank you very much, and I'll look forward to your ideas and questions if you have any.